public session. I have no apologies advised. This meeting has been convened, a meeting of the Select Committee on Justice and Equality, for consideration of committee stage of 2 bills. The first of which is the Criminal Justice Mutual Recognition of Probation Judgments and Decisions Bill 2018. Before we begin, members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against either a person outside the Houses or an official, either by name or in such a way as to make him or her identifiable. And I also remind people, members, to please switch off, and others, officials present, to switch off their mobile phones as they interfere with the sound recording equipment. We are joined by Deputy Charles Flanagan, Minister for Justice and Equality, and his officials, and you're all very welcome here this morning. There are just 3 proposed amendments to the first bill, all in the name of the Minister. Before proceeding to address each of the sections, which we are obliged to do, that will take a little time of itself. I would like to perhaps invite the Minister to make any opening remarks that he would like to put on the record. Minister.
Thanks, Caoimhghín, and I'd like to thank you and the committee for ordering your business this morning in a way that allows for debate on this matter, the Criminal Justice Mutual Recognition of Probation Judgments and Decisions Bill. It's required to implement an EU framework decision. The purpose of the bill, as members will be aware from previous debate at plenary session of the House, is to facilitate a person who is under supervision of the probation service in one EU member state but who lives in another member state to return home and undergo the matter of supervision there. The proposal in this bill, the aim of which is to increase the chances of social reintegration and rehabilitation of offenders who may be convicted of offences abroad, to better protect victims by ensuring non-resident offenders comply with probation conditions, and reduce unnecessary detention of non-resident offenders by ensuring non-custodial sentences can be enforced in the home state of that person. I would acknowledge the importance of these objectives and want to acknowledge the support of the House so far in the course of this debate, and look forward to the engagement. If the Chair permits me to proceed to Amendment 1.
No, we'll have to wait until we get to that particular point. We have a number of decisions to make on sections before we get to the 3 amendments.
Oh, you're right. It's not on page 20. You're right, of course.
And I'll bring you in at the appropriate time, Minister. So, with the opening remarks of the Minister already noted, I propose to take each section of the bill. Section 1, again, I'm not going to repeat the phrase ad nauseum. There are no amendments in the following sections until we get to Amendment 1. So I'm literally going to indicate that Section 1 stand part of the bill and repeat the same as appropriate as each section presents. So the proposition is that Section 1 stand part of the bill. Is that agreed?
Agreed.
Agreed. That Section 2 stand part of the bill. Is that agreed?
Agreed.
Agreed. That Section 3 stand part of the bill. Is that agreed?
Agreed.
That Section 4 stand part of the bill. Is that agreed?
Agreed.
That Section 5 stand part of the bill. Is that agreed?
Agreed.
That Section 6 stand part of the bill. Is that agreed?
Agreed.
That Section 7 stand part of the bill. Is that agreed?
Agreed.
Chair, sorry, just on
Yes,
Section 7,
Deputy Chambers.
It relates to expenses. I just want to know, Minister, what the what's the projected expense for this change, just so on for the record for future estimates to see how fluctuation occurs in expenses. Do you have any idea what it might be?
Well, this is a demand-led scheme. I don't have the figures, but I would be happy to provide this committee with information as to expenses as the Act is being implemented. have to say, however, that any expenses incurred shall be paid out of money sanctioned by the Minister for Public Expenditure in the normal way. So.
Okay, in the absence of the information immediately to hand, Deputy, you're happy that any information that may be to the Minister's access will be circulated through the clerk?
Yeah, I agree. I just think
it's the absence of it's not the absence of information. I mean, I don't expect, Caoimhghín, that you would be in a position to require of me how many cases we're going to have.
Of course.
How much is this going to cost? What I can say is what I've already said, that I would be happy to keep Deputy Chambers in particular and the committee updated. But I have to say, it doesn't strike me as this is going to be in any way drain on exchequer funding, if that's the import.
No, there's no import. I think the import is that I think it's important when we're providing for legislation that your department has a projected cost for matters of public policy, rather than we've seen matters around the Department of Public Expenditure and Reform. I think we've due diligence as a committee chair to ask the question. I think your department has a duty to provide the answer on a projected scale, and rather than being a generic response. So I just think, for the record, it's important when we're bringing forward legislation that we ask that question and that you provide an answer for it.
Thank you, Deputy Chambers. Minister.
Yeah, I can. I can put forward by way of estimate, and of course would be happy to correct the record in the event that the estimate doesn't turn out to be accurate, but we're talking small numbers here. It's estimated we could be talking less than 15 orders, and also there will be a balance between persons that will be leaving this jurisdiction and persons that will be arriving in this jurisdiction. I'm really not in a position to provide full details of the cost, other than to say that, of course, the issue of cost will be borne by the department in the normal way, and I will be accountable on the matter of the estimates debate. But we're talking small numbers here, and I wouldn't like Deputy Chambers, or indeed any other deputy, to say that this is going to present an inordinate drain on.
Nobody has, Minister,
funding.
with respect.
I didn't say.
Nobody has.
Nobody has. No, but I think look, there's no import. There's a legitimate question asked based on a section of the bill on expenses. You can't provide an answer. I think it's important, in light of a lot of issues around public expenditure, that we ask questions around expenditure. Well, we've serious divisions between government and that department, so I think we've...
Yeah, but what examples are we drawing on, having regard to the fact that the Chair has already said that the Deputy isn't making an inference?
Making an inference, but general... I have a duty to ask a question about public expenditure if you're providing for an expense that you can't answer a question on. It could be, I think I'm entitled to ask the question, Minister.
Right. Well, look at what I propose is the Deputy is absolutely right that it is reasonable for him to put the question. There is no inference in what he is posing to you. In the absence of any... sorry, Minister, with respect. The Chair is addressing you and the rest of the committee. What I'm saying is that in the absence of any detailed information, speculative or suggested in terms of the likely traffic as a result of the passage of the bill, you might, at the earliest opportunity, see if there is projected costings that can be shared with the committee. And if you come back accordingly, that's what I understood. Agree to that. That's what I understood.
Yeah. Thank you.
So we'll work on the basis that you will do so.
We will.
Thank you.
Yeah. And the Chair and members of the committee will acknowledge that this is a standard provision.
Thank you, Minister. So again, I put the question that Section 7 stand part of the bill. Is that agreed? Caoimhghín. That Section 8 stand part of the bill. Is that agreed? Caoimhghín. That Section 9 stand part of the bill. Is that agreed? That Section 10 stand part of the bill. Is that agreed? That Section 11 stand part of the bill. Is that agreed? That section 12 stand part of the bill. Is that agreed?
Agreed.
That section 13 stand part of the bill. Is that agreed?
Agreed.
That section 14 stand part of the bill. Is that agreed?
Agreed.
That section 15 stand part of the bill. Is that agreed?
Agreed.
That section 16 stand part of the bill. Is that agreed?
Agreed.
That section 17 stand part of the bill. Is that agreed?
Agreed.
That section 18 stand part of the bill. Is that agreed?
Agreed.
That section 19 stand part of the bill. Is that agreed?
Agreed.
That section 20 stand part of the bill. Is that agreed?
Agreed.
That section 21 stand part of the bill. Is that agreed?
Agreed.
That section 22 stand part of the bill. Is that agreed?
Agreed.
We're on to section 23, and the first of the three amendments presents, all of which are in the name of the Minister, an Tara Dlí agus Ceart agus Caoimhghín. I'd invite the Minister to address amendment number 1, please.
Amendment number 1, thanks, Caoimhghín. This is a technical amendment, removes the proviso that section 23(5)d is subject to subsection 6 of that section, as I don't believe it's necessary. Subsection 6 doesn't relate to subsection 5d, and therefore it's my contention that the inclusion of the text has no effect. In that regard, I should say that the proviso was originally included in what was an earlier draft of the bill. It should have been removed when it was considered to be no longer necessary. And my contention, Chair, is that this amendment deletes text that I would invite committee members to agree with me is perhaps superfluous.
Thank you, Minister. Would any member wish to address the Minister's proposed amendment?
I agree with the amendment.
Agree with the amendment. Thank you, Deputy O'Callaghan. There are no others showing. In that case, I propose to proceed to put the proposition, and that is that the amendment number 1 in the name of the Minister, that the amendment be made. Is that agreed?
Agreed.
Agreed. Caoimhghín. We move on then to address the section. That section 23 now is amended. Stand part of the bill. Is that agreed?
Agreed.
Agreed. Caoimhghín. We move on to section 24 and the second of the Minister's 3 amendments. This is amendment number 2. I'd invite the Minister to please address his amendment.
Thanks, Caoimhghín. Amendment 2 is also a technical amendment. It's similar to amendment number 1, which we've just made, in that it removes a proviso that section 24(6)d is subject to subsection 8 of that section. And again, I'm of the view that this is unnecessary because subsection 8, which sets out further grounds for refusal to endorse a judgment, doesn't relate to 6d. And again, I would say that the text is superfluous, and I make the amendment probably to bring a greater level of clarity.
Thank you, Minister. Would any member wish to address the Minister's proposition?
Yeah, I agree with the amendment. I think it does bring a greater level of clarity.
Thank you, Deputy O'Callaghan. Any other member? Okay, Deputy O'Leary, you're indicating agreement. Thank you. Okay, in that case, there are no other indications. I put it to the committee, therefore, that amendment number 2 in the Minister's name, that the amendment be made. Is that agreed?
Agreed.
Agreed. Caoimhghín. There are no other amendments in this section, so the proposition, therefore, is that section 24, as amended, stand part of the bill. Is that agreed?
Agreed.
Agreed. Caoimhghín. We move on now to a number of sections with no amendments. That section 25 stand part of the bill. Is that agreed?
Agreed.
That section 26 stand part of the bill. Is that agreed?
Agreed.
That section 27 stand part of the bill. Is that agreed?
Agreed.
That section 28 stand part of the bill. Is that agreed?
Agreed.
That section 29 stand part of the bill. Is that agreed?
Agreed.
We're on to section 30. The third of the Minister's amendments presents in this section. I'd invite the Minister to address amendment number 3.
Thanks, Caoimhghín. And again, I would contend that this is a technical amendment. It corrects something of an error in a cross-reference in subsection 1A of section 30. members will see that Section 30 provides that in certain circumstances where a conditional release order is transferred into the state from another member state, that other state will retain responsibility for taking any subsequent decisions that might in the circumstances be required. The Section 30 only concerns conditional release orders, which are the subject of Section 25(2), and therefore it seems to me the cross-reference should be to that section. Section 25(1), as we have already seen, concerns suspended sentences. So that was referenced in the bill in a way that perhaps it shouldn't have been, and I want to correct what essentially is an error.
Would any member wish to offer a view in relation to the Minister's Amendment number 3?
I agree with the amendment. It clears up a mistake in the original bill.
Deputy O'Callaghan.
Thank you.
Deputy O'Leary, you're indicating the same. Thank you. In that case, I will now put Amendment number 3 to the meeting. That the amendment be made, is that agreed?
Agreed.
Agreed. We move on then to the section. That Section 30 as amended stand part of the bill, is that agreed?
Agreed.
That Section 31 stand part of the bill, is that agreed?
Agreed.
That Section 32 stand part of the bill, is that agreed?
Agreed.
Schedule. The schedule be the schedule to the bill, is that agreed?
Agreed.
That this be the title to the bill. An Act to give effect to Council Framework Decision 2008-947 JHA of the 27th of November 2008 on the application of the principle of mutual recognition to judgments and probation decisions with a view to the supervision of probation measures and alternative sanctions, as amended by Council Framework Decision 2009-299 JHA of the 26th of February 2009, amending Framework Decisions 2002-584 JHA, 2005-214 JHA, 2006-783 JHA, 2008-909 JHA and 2008-947 JHA, thereby enhancing the procedural rights of persons and fostering the application of the principle of mutual recognition to decisions rendered in the absence of the person concerned at the trial, and to provide for related matters. Is that agreed?
Agreed.
Agreed. As consideration of the bill has been completed, in accordance with Standing Order 90, the following message will be sent to the Clerk of the Dáil. The Select Committee on Justice and Equality has completed its consideration of the Criminal Justice Mutual Recognition of Probation Judgments and Decisions Bill 2018 and has made amendments thereto. I now suggest that we suspend the committee meeting for a minute to allow for the officials accompanying the Minister to change before commencing with the second bill, the Civil Law Presumption of Death Bill 2016. And I'd like to thank the officials. We now move on to the Civil Law Presumption of Death Bill 2016. There are a number of proposed amendments, all in the name of the Minister. I refer you to the grouping list. Has that been distributed?
Yeah.
Yes, thank you. I again invite the Minister, if he would wish to make some opening remarks on this bill. Minister, please.
Thanks, Look, I merely wish to acknowledge the order of business, the ordering of business by the committee to facilitate debate on this bill today at committee stage. I very much welcome the opportunity to engage with deputies in order to ensure that we can report progress. In that regard, let me say that I'm joined on my left by officials Regina Terry and Mary Joy. We're joined by Philip Murphy from the GRO in the event of there being an issue of concern relating to that office. We have something like 9 parliamentary weeks left, and this is a piece of legislation that I would hope all members of the House would see their way towards advancing. It was a private member's bill in the Seanad, and I want to acknowledge the sponsors of the bill, Senators Mary-Louise O'Donnell and my own colleague, Senator Colm Brophy, and maybe Senator Lynn as well, indeed, Senator Rowan. So I would be happy to engage at committee stage. Thank you.
Minister, before proceeding, and just for the information of members, just to record the fact that I note that the money message is on the order paper for today.
Oh, yes. Thank you.
Very good. The groupings, yes, the members will note with some interest. And here we go. The first amendment is part of a grouping 1 to 4 inclusive. All of the amendments, I understand, are in the name of the Minister. Section 1, these 4 amendments, 1, 2, 3 and 4 together. I invite the Minister to address the grouping, please.
Thanks, Caoimhghín. 1 to 4 together. Amendment number 1 is a technical amendment to update the citation provision for the Civil Registration Acts consequent upon the changes being introduced in this bill. The combined effect of Amendments 2, 3 and 4 is to provide that the commencement order for Part 3, which amends the Civil Registration Act of 2004, will be subject to consultation with my colleague Minister for Employment Affairs and Social Protection. The rationale for this is that the bill is amending legislation for which that Minister has something of primary responsibility. Thank you.
That concludes your remarks, Minister, in relation to the 4 amendments.
Yeah.
Would any member wish to add any comment or opinion?
I think the amendments make sense.
Deputy O'Callahan?
I think the amendments make sense and I agree with them.
Agree with them? Anyone else indicating or wishing to? Deputy O'Leary, thank you. Deputy Chambers, thank you. In that case, we'll proceed to address each of the amendments standalone. The first amendment, in the name of the Minister, that the amendment be made, is that agreed? Caoimhghín. Amendment 2, that the amendment be made, is that agreed? Caoimhghín. Amendment 3, again, already discussed with Amendment 1, that the amendment be made, is that agreed? Caoimhghín. Amendment 4, already discussed with Amendment 1, that the amendment be made, is that agreed? Caoimhghín. All 4 amendments in the first section have been agreed, and therefore I put the proposition that Section 1 of the bill as amended stand part of the bill. Is that agreed? Agreed. Moving on to Section 2, there are 2 amendments here. They're both grouped, Amendments 5 and 6. Minister, please.
5 and 6, Caoimhghín, thank you. In respect of Section 2, these are technical amendments. Can I say, in relation to number 6, the purpose is to remove any potential ambiguity that may arise around the fact that the term applicant, as used in a Section 8 context, means an applicant as defined in Section 4. The term is used in Section 4 where an application is being made for a presumption of death order. It's also used in Section 8 where a variation order is being sought in respect of what was an original presumption of death order. So it's for clarity. Can I just say an application in section 4 is defined, an applicant rather, the spouse or civil partner of the missing person, the cohabitant of a missing person, any other family member of the missing person, including a child, grandchild, parent, grandparent, brother, sister, half-brother, half-sister, uncle, aunt, nephew or niece of the missing person, a person who is acting in loco parentis to the missing person, a dependent of the missing person, or indeed any other person with a sufficient interest, including where relevant the Attorney General or other person acting on behalf of the state in circumstances. It's my view that is all-embracing.
Thank you, Minister. Any member wishing to address this grouping, amendments 5 and 6? No? We okay?
Yeah,
all right, in that case.
Yeah.
In that case, we'll proceed. Amendment number 5, in the name of the Minister, that the amendment be made. Is that agreed?
Agreed.
Caoimhghín. Amendment number 6, already discussed with 5, that the amendment be made. Is that agreed?
Yep.
Caoimhghín. There are no other amendments in this section, so the proposition is that section 2 as amended stand part of the bill. Is that agreed?
Yeah.
Caoimhghín. There are no amendments in section 3, that section 3 stand part of the bill. Is that agreed?
Agreed.
Caoimhghín. On to section 4, there's a standalone amendment in this section, but it is part of the grouping 7 to 14, which takes in all the amendments in section 5, and an amendment number 14 that presents in section 15. So it's a grouping 7 to 14 inclusive, and the first of these presents in section 4, amendment number 7. Minister, would you address the grouping, please?
Thanks, Caoimhghín. 7, 8, 9, 10, 11, 12, 13 and 14. Again, my contention would be that these amendments are technical in nature. 7, 11 and 13 provide for the deletion of text that I would regard as being extraneous. Amendments 8, 9, 10 and 12 concern punctuation issues. Amendment 14 provides that neither Part 5 nor Part 5A of the Civil Registration Act of 2004 shall apply to a presumed death, corrects an earlier omission of reference to Part 5A. In that regard, members should note that Part 5 concerns the registration of deaths in general, and 5A concerns the keeping of a record of deaths abroad. So I contend that they're technical amendments, and I would seek support.
Thank you, Minister. Again, I invite members to address the grouping, either any individual amendment between 7 and 14 inclusive, or the entirety of the amendments involved. There are 8 amendments in the grouping. Anyone?
No, there are technical amendments, and they're
They are, as the
appropriate.
Minister describes.
Thank you.
We're all happy with that. Very good. We'll proceed then with amendment number 7 in section 4. That amendment number 7 be made. Is that agreed? Caoimhghín. There are no other amendments in this section, so the proposition is that section 4 as amended stand part of the bill. Is that agreed? Caoimhghín. Into section 5, amendment number 8, already discussed with 7, that the amendment be made. Is that agreed?
Agreed.
Amendment 9, already discussed with 7, that the amendment be made. Is that agreed?
Agreed.
Amendment 10, already discussed with 7, that the amendment be made. Is that agreed?
Agreed.
Amendment 11, already discussed with 7, that the amendment be made. Is that agreed?
Agreed.
Amendment 12, already discussed with 7, that the amendment be made. Is that agreed?
Agreed.
Amendment 13, already discussed with 7, that the amendment be made. Is that agreed?
Agreed.
That concludes the amendments in section 5. So therefore, the question is that section 5 as amended stand part of the bill. Is that agreed?
Agreed.
Moving on to section 6, there are no amendments. That section 6 stand part of the bill. Is that agreed?
Agreed.
No amendments in section 7. That section 7 stand part of the bill. Is that agreed?
Agreed.
That section 8 stand part of the bill. Is that agreed?
Agreed.
That section 9 stand part of the bill. Is that agreed?
Agreed.
That section 10 stand part of the bill. Is that agreed?
Agreed.
That Section 11 stand part of the bill. Is that agreed?
Agreed.
That Section 12 stand part of the bill. Is that agreed?
Agreed.
That Section 13 stand part of the bill. Is that agreed?
Agreed.
That Section 14 stand part of the bill. Is that agreed?
Agreed.
We're on to amendment number 14. In Section 15, this has already been discussed with 7 in the grouping now concluding. So the proposition is that Amendment 14 be made, that the amendment be made. Is that agreed?
Agreed.
Moving on to amendment number 15. This is part of a grouping, 15 to 26 inclusive, which is the entirety of the remainder of the amendments. They're all in the name of the Minister. I'd invite the Minister to address amendments 15 to 26 inclusive.
Thanks, Caoimhghín. Members will be aware that the bill currently provides that the appropriate registrar shall be provided with a copy of the presumption of death order, or indeed the variation order, if applicable, by the court which made that order, and that the appropriate registrar shall register the death or remove the entry from the register, again depending on the circumstances, as appropriate. The appropriate registrar is a registrar in the functional area of the authority in which A, the death was presumed to have occurred, or B, if a place of presumed death cannot be determined, the area in which the missing person was normally resident. The amendments which are proposed are in the interest of the efficient management of the registration process. They allow on Tord Clara Hor the flexibility to perform registration centrally, or indeed to assign the task to a registrar, thus simplifying the registration process by comparison with the process set out in the bill as was passed in the Shannon. The proposed arrangements would also act to provide a single point of contact for receipt of court orders. I have to say here, Caoimhghín, the text has regard to the wording used in section 65.3 of the 004 Civil Registration Act, to which I have made reference earlier. Again, it's in the interest of efficient management, careful management of the process, to allow for clarity. So I'd ask that these amendments be given favourable consideration by your members, Caoimhghín.
So would any member wish to offer any opinion in relation to this grouping?
I think that makes sense, yeah.
Deputy Chambers?
Yeah, I agree with the Minister. That makes sense.
With the Minister. And there's no other indication of comment. So we'll move on then to deal with the amendments individually. And the proposition therefore is that Amendment 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 16 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 17 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 18 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 19 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 20 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 21 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 22 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 23 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 24 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 25 already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Amendment 26, the last of the amendments, already discussed with 15, that the amendment be made. Is that agreed?
Agreed.
Concludes address of the amendments as tabled. So the proposition at this point is that Section 15 as amended stand part of the bill. Is that agreed?
Agreed.
Section 16, there are no amendments to this section, so the question is that Section 16 stand part of the bill. Is that agreed?
Agreed.
The title, that this be the title to the bill. An act to provide for the civil status of a missing person where the circumstances of his or her absence leads to a presumption of death and to provide for related matters. Is that agreed?
Agreed.
As consideration of the bill has been completed in accordance with Standing Order 90, the following message will be sent to the Clerk of the Dáil. The Select Committee on Justice and Equality has completed its consideration of the Civil Law Presumption of Death Bill 2016 and has made amendments thereto. I again thank the Minister's officials for attending here this morning. If the Minister would like to make any concluding remark before drawing the meeting to a close.
No, other than to express my appreciation to you, Chair, and to the members of this committee for dealing with this piece of legislation. I said in the context of an earlier piece of legislation, we have about 9 weeks left in this parliamentary session. This is an important piece of legislation, and I would be very keen to ensure safe passage through the plenary session of the House at report stage, and I know that there are members here who will have an interest at that stage. Would be very keen to have it enacted and to have a commencement order made at the earliest opportunity. I want to acknowledge the sponsorship of the bill by our colleagues in the Seanad, and just to thank the members of this committee for the efficient management of committee stage, for which I'm grateful. Thank you.
Thank you, Minister. Just for members' purposes, just to remind you that we're back to the 9 a.m. start for the Joint Committee next Wednesday, when we will commence a series of hearings in relation to direct provision. The Select Committee is now adjourned sine die. Caoimhghín.